Salutations, respected viewers. This is George from Ireland. I'm carrying on my series about English law. So looking at tort and my favourite area of it, which is defamation, particularly libel, as when one publishes a statement which allegedly damages somebody's reputation and is untrue. So it must satisfy both conditions. It must be damaging the reputation and false. If it harms a reputation but it's true and you can prove it's true, then you're entitled to publish it. All right, so if someone feels that he has been libelled, then he may issue a writ about that. The person has 2 years to do that from the time that the supposedly libelous statement is published. For instance, supposing the alleged libel was published on the 1st of January 2000, then the last day he could issue this writ would be the 1st of January 2002. If, however, that said libel was republished on the 2nd of January 2002, that would extend the period for which you could issue a writ. It would extend it by a further 2 years, up to the 2nd of January 2004. So for each republication extends it. There's another 2 years from the most recent publication in which somebody can issue a writ saying, I'm taking you to court for libel. So the person who claims that his reputation has been damaged is the claimant. He is claiming this is done and he's claiming damages. You must publicly apologize and pay me money because you can't exactly give me my reputation back, but to make it up to me and also to penalize others. Let that be a warning to anybody who might besmirch someone else's reputation. The claimant does not have to take action against the original publisher. Supposing the Times newspaper were to publish a libel, but then the BBC was to repeat it, the claimant might choose to take action against the BBC and not against the Times. Sometimes it's a person of straw, somebody with no money, like me, who says that, well, it's not worth suing because we could bankrupt him and get about a fiver. So therefore, if a wealthy person or institution published it, what he said will go after them. The party who has allegedly committed the libel can offer accord and satisfaction. This means an apology in a public manner and withdrawing the statement, saying, I now accept that that is bogus. Now, the party who was offering accord and satisfaction will probably offer a sum in damages, which should be commensurate with the harm inflicted on the person's reputation, on the claimant's reputation. Now, the claimant could accept accord and satisfaction and say, that closes the matter, and obviously have to sign a legal document to that effect. However, the claimant could reject the offer of accord and satisfaction, and the case proceeds to court. The court's view is if the two parties can sort it out for themselves and agree amicably, fine, that's better if they don't have to go to law. Now, the court could find that the statement was indeed libelous, but the accord and satisfaction was sufficient. Therefore, the claimant ought to have accepted that accord and satisfaction, and on that basis, the court might find in favour of the defendant. Yes, it was libelous, but you were offered a reasonable deal, you turned it down, well, we're going to find for the defendant. On the other hand, the court might say there was a libel in the first case. Second of all, there was accord and satisfaction, but the offer made was not enough. Therefore, as the claimant, you're right to turn it down, we still find for the claimant. Now, many times there is no accord and satisfaction offered. The claimant makes a claim, the defendant says, see you in court, I'm not going to offer accord and satisfaction, I'm not going to apologise and offer to pay you whatever sum I think see fit. Now, if the court decides there was no libel, then the defendant wins. That means the defendant has proved what he said, what he published was true, or indeed that the claimant's reputation is already so terrible that there's no reputation left to damage. If you're in prison for murder and somebody false accuses you of shoplifting, well, your reputation is so bad that saying that you shoplifted, even if you didn't, isn't going to make your reputation any worse. Anyway, if a defendant has already offered accord and satisfaction, it's unlikely they'll find in favour of the defendant unless the accord and satisfaction was pitiful. Because if you offer accord and satisfaction as a defendant, that means you're already admitting you harm the claimant's reputation in an unprovable manner, or indeed a false manner. But if the statement was true and could be proven to be true, then the defendant would not have offered accord and satisfaction. Remember, it's about what you can prove, what was actually true. Now, it's about going up to the line. The media do not like to be overly circumspect. Look at Boris Johnson. And he's the case in point. People make all sorts of statements about him which damage his name, but he's someone who really causes controversy, and he doesn't sue them, partly because of the things they say about him. They say about his extramarital affairs are true, like the extramarital affair he had with Anne McElvoy, who ran about 2002. We'd miss out on many juicy stories if newspapers were overly cautious and other broadcast media. So they sometimes stray over the line of what is safe to print. They do so because they're taking a calculated risk. They assume that such a person is not going to take an action against us. Maybe he doesn't have money for it. Incidentally, there's no legal aid for libel. If you have a civil matter you need to resolve, you can apply for legal aid since the 1940s. And if you have a reasonable case, you'll be given some money, and some of the solicitor's fee, or indeed all of the solicitor's fee, barrister's fee, might be paid, depending on the situation, your income. But for this one, for libel, there is no legal aid. You are entitled to represent yourself as unwise. The last person I can think of who did so was, that histortionist, the Holocaust denier bloke, David something or other, around about 2002, when he took out a claim against Deborah Lipstadt, but lost. Anyway, the name escapes me. This is the only civil wrong case where there is sometimes a jury. A case comes to court. The judge says, do you want this to be tried by a jury or by a judge? And the parties could agree, both want jury, both want a judge. If they can't agree, the judge has to decide, should I hear this alone or should a jury hear it? Anyway, then it goes ahead. So if libel is proven, then the person or party that committed the libel must retract the statement and apologise. Incidentally, I should have said a party might be an individual or might be an institution, might be several individuals. So we use the generic term a party. So a person or a party, well, that's the same thing. I shouldn't have distinguished. That's legal terminology. So damages can be awarded if somebody was libelled. Now, they could be derisory, like £1, because they think that the damage was so slight, or the court takes a very dim view of the claimant. Or it could be millions of pounds, as the court deems fit. Costs can be in the millions. If the claimant wins, his costs are awarded. This could bankrupt the defendant. It could work the other way around. So it's a high-stakes game. It's a rich man's game. George Carman was the king of libel. The trouble is, they say London is the libel capital of the world, and often cases which have little to do with England and Wales are heard there, because they would damage my reputation in England, even though I'm living in America and it was somebody in Mongolia who did it. That'd be a pretty unlikely example. So that's that. Okay, so on to liability, and this is in tort generally, not just for libel. So tort is what one is liable for. If you did some harm to another, then you will have to pay for the harm you have done. If you owe someone a legal duty, if that duty is breached and harm results, then you are liable in tort for the damage caused. You have done wrong to them, even sometimes if by accident. Imagine the fictive Whittle-Whop school. At Whittle-Whop, they're supposed to keep the pupils safe. It's their statutory duty. However, the fire alarms do not work, and it never does fire practices. Supposing a fire were to break out and the school is not evacuated in time, a child dies as a result. The parents could obviously take legal action. You had a duty of care. You owed a duty to your pupils and a duty to us, the parents, indirectly. You failed to do that. You did not take reasonable steps. There was no due diligence. A death resulted. But for your failure to keep the fire alarms in working order, to do fire drills, our child would probably be alive. Not certainly. We don't have to prove it's certain. Just fairly high chance. Therefore, you're liable and damages to us. Conversely, if the school did everything they should have done and a child still died, well, they can't be held liable, because liable rather than libel. So liable is like responsible, whereas libel, L-I-B-E-L, is as in you lied, you damaged my reputation. Right, coming on to vicarious liability. Vicarious is doing something on behalf of another. A vicar is doing something on behalf of a bishop. If somebody commits a tort, he is usually primarily liable. I say this because people can be held responsible for their actions. Often it's the case with children, those who are not compos mentis, someone else is held answerable for their actions. Vicarious liability is being liable for the torts of another person for whom one is responsible. So parents being responsible for their children, for instance. In Home Office and Dorset Yacht, some juvenile delinquents were being held at a borstal. These young offenders were on an outing under the supervision of the guards. The boys ran amok and they smashed up a yacht. The owners wanted to sue the guards for being primarily liable for the damage inflicted. Note, the young offenders were not responsible. They were minors and the prison officers, they were responsible for the boys, supposed to control them. And the Home Office was held to be vicariously liable because they were ultimately in charge of the guards. They were indirectly liable. So the young criminals did not have tortious liability. Coming on to medical negligence. Right. So doctors, nurses, dentists, paramedics, other medical staff need to be very careful indeed. They need to exercise due diligence in all they do. They must verify that a patient understands the medical procedure and consents to it if he is an adult of sound mind. In emergency situations, this won't apply. There's no time to explain the intended course of treatment. Somebody comes in with a heart attack. We're not going to say, do you agree? Do you want to sign a form? They just do it. Somebody's unconscious. They just do it. Somebody's heavily bleeding. No, I don't want a blood transfusion. They would just do it. Non-emergency situation, like, say, cancer treatment, an adult of sound mind is entitled to refuse treatment, right? Of sound mind, not mentally ill, and not of subnormal intelligence. You can be a bit dim, but if you're really very far below average, it may be found that in effect you are not an adult, and you'll be treated even against your wishes. So children are sometimes treated against the wishes of their parents if it's a matter of life and death, or there's no chance to contact them. So extreme caution is sometimes harmful. Every operation is a risk. However, operating is usually less dangerous than not operating. Someone needs stents in her heart, but she might die in the operation. But if we don't do it, she's probably going to die in a year. If we do it, she might die in a few minutes. But overall, the risk is judged to be acceptably low. And the long-term benefits of the stents in the heart, she's going to live another 10 years. So we'll do it, for instance. However, the woman would be entitled to refuse in this case. If a car crash victim is brought in, as I say, the surgeon just operates. They're not going to ask. Okay, so many operations are elective, as in they are not necessary, not a matter of life and death. There's going to be quality of life. Some babies are born with an extra toe. They're usually surgically removed. But you'd only do that with parents' permission because it's not urgent, it's not necessary. You could live with an extra toe. Doctors have to explain the results the risks associated with the procedure to the patients. They must have informed consent. They decide to go ahead or not. A nose job is not medically needed and it has some risks. It can make your nose worse. I don't know if you could even die, but certainly breast augmentation, people have very occasionally died having it. Now, there's more than one way to skin a cat. There might be more than one legitimate means of dealing with a problem. The doctors can be legally protected if whichever the option they go for is supported by a reasonable body of professional opinion, or as the language says, legal language says, supported by men who are skilled in that art. No, they did say men in those days when only males could be physicians. So doctors must not be negligent. Doctors and other medical staff who neglect their duties may be tortiously liable. They may have to pay compensation and indeed be disbarred from their profession. So their medical insurance things have to pay these malpractice suits. In the hospital or the medical trust, they will have to pay, not the individual doctor. So the trouble is that doctors then practice defensive medicine. They do things for legal and not medical reasons. And the problem with that is very acute in the United States. They're doing things according to a legal rationale. And instead of being cautious, they become extremely, extremely cautious. The most minor complaints are examined in extreme detail, which is hugely time-consuming, drives up the costs of care. Some people can't afford medical care at all and don't get treated for minor things, which turn into serious things and kill them. So some of the tests are just vanishingly unlikely to be necessary. So doctors are trying to document, they're trying to cover their ass, have a paper trail, and it's, as I say, it's done for legal, not medical reasons. We don't run law on the basis of medicine. We shouldn't run medicine on the basis of law. So there we are. That is a very brief whistle-stop tour of medical negligence and other areas of tort.